Good morning. We'll go ahead and get started. Can you all hear me?
Yes, Your Honor.
Okay, great. The Sixth District Court of Appeal is back in session. I'll go ahead and reintroduce myself because I don't know if you were listening in on the first session that we had today. I am Carrie Ann Wozniak, presiding judge from Orange County. I have Roger Ganem to my right, also from Orange County. And then to my left, I have Steve Berlin, an associate judge from the Sixth Circuit. And we're very excited to have him today with us for this case. I'll go ahead and call this case now. It's 23-544. Christopher T. Knott versus Tracy L. Knott, and also a reminder that we are recording this session. Appellant's counsel, how much time would you like for rebuttal?
5 minutes, Your Honor, if I may.
Okay, great. That is noted. And you can go ahead and get started when you're ready.
Thank you, Your Honor. May it please the court. My name is Mark Silverio. I'm the attorney for the appellant, Christopher Knott, along with my co-counsel, Parker Hall, who assist on the brief and in this oral argument. As the court noted in the briefs, there are a number of points on appeal. And before I jump into them and argue some of the key points, I'd ask if the court has any questions of me to begin. I would be glad to answer them before I start.
You may proceed.
Thank you. The first point I'd like to present to the court is dealing with the issue of the valuation of the husband's business, which was the Naples Security Solutions, Inc. There are basically two issues that I raise with respect to this. One is that the trial court abused its discretion in adopting the wife's expert opinion on the value of this business. For two reasons. One is when the wife's expert, which the court adopted, calculated this business on a net asset value, she double dipped the valuation so that the husband was penalized in two ways. They used the bank balance in this net asset value of $341,197 to be the asset value of the business. There was an additional vehicle which brought the value up to $389,000. But they used the very same bank balance and the very same income, very same cash to calculate the husband's income for alimony purposes. The findings of the trial court clearly indicate that the income that the court found was $318,323 a year, which was the cash that he removed from this bank account for purposes of paying his expenses, his business expenses, and other personal expenses. So when you look at the big picture, the valuation on the net asset value, he gets penalized with that cash balance, resulting in the value of that business of over close to $400,000. And then that very same number, that very same amount is used by the trial court again to determine the alimony, his ability to pay. And that, I submit, was abuse of discretion of the court. Appellate counsel, appellee counsel, argues that there's no double dip because, first of all, there's no Florida case on double dipping. Well, I submit he hasn't found a Florida case that says that there is no double dipping process here. Double dipping is inherently unfair when you penalize a spouse two ways, for an asset value on an equitable distribution and also for an income for alimony purposes. The only argument that he really makes is he cites a New Jersey case, Steniken, out of New Jersey, but it's distinguishable. What he argues is that the valuation in this particular case only captured past income and not future income. That's incorrect, because there was no other finding in this record as to what the future income was of Mr. Knott, other than what the monies he drew out of that bank account, the business bank account. Another key distinction is that in the Schenken or Stenkin case, it was a capitalized earning valuation approach, which by the very nature of that method, it captured past income, for sure. But it also made a finding in that case that the husband had future income for purposes of alimony. In our case, there was no finding by the court that there was any future income of Mr. Knott other than the bank balance and cash he withdrew. So that in our net asset value determination, past income and future income is captured in that bank account, which was the double dip. The second point I'd make on the valuation is that the court abused its discretion in using the date of filing as opposed to date of trial. Because the record is pretty clear. Actually, the record is very clear that there's competent, substantial evidence to show that Mr. Knott withdrew out of that bank account various business expenses post-filing to pay various bills. All of those expenses are in the record. Actually, they're in the wife's expert report. That's Mrs. Bastian's report, appearing on as Exhibit 14, Volume 6, tabs 1 and 4. She lays out in particular detail in her schedule all of the business expenses that the appellant paid out of that account. So it's inherently unfair, abuse of discretion to use date of filing numbers when the date of trial balances showed a significant amount of expenses being paid. Also, the husband's expert also tracked all those expenses. So the record is pretty clear that they're in the record as to what he paid. And this valuation was significantly prejudicial to him because it was put on the spreadsheet at $389,000, which was probably a difference of about $264,000 had you looked at the real expenses that were deducted from that account. So this was a significant factor in the overall equitable distribution.
Counsel, if I may ask you regarding the timing of the valuation, I believe the trial judge had the discretion to choose the appropriate date for the valuation. In a case where a business is valued, at some number at the date of filing, but then a lower number at the time of trial, is that decrease in and of itself justify valuation at the later date, or are there other things that the trial judge should have looked at and that we should consider to determine whether the trial judge abused its discretion?
It seems to me, Your Honor, that if you are looking to determine a net asset value, a real value of this business, one had to step back and look not just at a snapshot of a bank balance as of date of filing, when the record was very clear that this bank account was used for the purpose of paying significant expenses at the time of valuation and post-filing, so that we submit that the court abused its discretion by disregarding all of real expenses that came out of that account post-filing. But in the overall argument on this point, this court can reverse the valuation on the grounds of the double dipping, even if the court accepts the date of valuation to be the date of filing, because the double dip creates the inequity and the unfairness and the abuse of discretion. I only raised this point on the date of valuation as being a subsequent supporting argument, an additional reason for the court to reverse that valuation issue.
Sir, can you address the timing of or the classification of these motorcycles and the deposit as marital?
Yes. I would cite to the court a case that came out of this court recently on this issue, the McPherson case that was decided on May 10th. And that case holds specifically that if an asset does not exist at the date of filing, then the court has no discretion to determine that particular asset to be a marital asset. And it was undisputed in the record that those two motorcycles were acquired post-filing. And in fact, the wife's expert shows on her spreadsheet exactly when they were purchased. So I think the answer to the question, Your Honor, is that with respect to the hard, bright line rule on classification of assets, the date of filing is clear. Your McPherson case out of the 6th District clearly states that the court has no discretion to determine an asset to be marital if it was acquired post-file. So I hope that answers the court's question with respect to that.
Thank you.
Back to another point that I'd like to make with respect to the abusive discretion is the alimony issue. And it ties into the first argument I made. The law is pretty clear that in order to determine a spouse's ability to pay alimony, you must look at net income. Net income in this particular case was disregarded. The only deduct that was made for net income was for taxes. But all of the husband's expenses that were paid out of this account that we've been talking about were disregarded. They should have been netted out of that account. And I refer the court to this Lopez case that was decided this year, cited at 385 Southern 3rd, 1090 out of the 4th District, which clearly states the law that net income for purposes of alimony must include expenses, and these were legitimate expenses, and taxes. And that was not done in this case. That number of $318,000 of yearly income that Mr. Knott was hit with did not net out any of his normal, proper business expenses.
So the
for
revenue decrease was undisputed, correct? But what
Correct.
you're arguing was disputed. This issue was.
That's correct.
Okay.
That's correct. And I'm not arguing in this particular argument that there was, I'll leave it to the brief to argue with respect to how the court calculated his actual gross income for purposes of this alimony. But we don't have to even get there because the issue really is, did the court properly calculate the net income for purposes of alimony? And we submit that it did not. And I would point out to the court that both experts, Mr. Nesbitt on my side, Ms. Bastian on the wife's side, all showed schedules in the court file, which in the trial, in the evidence, which showed all of these expenses that were actually paid by Mr. Knott out of his income. Next point I'd like to make is the trial court committed legal error by dismissing the husband's partition claim, claiming it did not have jurisdiction. And the sole reason the court didn't consider that and awarded all the equity of the marital home in excess of $600,000 to the wife was because the court found that the husband didn't properly plead the quantity of ownership in the record. And I would point out to the court that first of all is incorrect. The court looks at paragraphs 27, 28, and 29 of the counter petition of the husband, which was at docket number 75, and the wife's answer, which is docket number 76. Clearly, there was proper pleading. The husband pled that the parties owned the house by joint tenancy, tenancy in common, tenancy by the entireties, or some other form of co-ownership. And the wife admitted that in her answer. Also admitted that the property is indivisible and not subject to partition without prejudice, which means it was jointly owned. And
The final judgment on page 9 says even at trial, no evidence was admitted specifying the quantity of interest each had in the marital residence. Do you agree with that?
I do not agree with that. In fact, I would point out to the court that the husband testified, and counsel cites it in his brief, and I cited in mine, that Mr. Knott testified that they were both on the deed. And when you have husband and wife both on the deed, you have a tenancy by the entireties, and you have a description of the quantity of ownership. And also, for purposes of the trial, the equitable distribution schedules had the residence on the schedules as a joint asset. And also, there was testimony as to the value of that property and what debt was on it, and that debt was joint. So I argue that even assuming the pleading requirement was not met, the evidence was in the record by an implied consent, and I'm not saying the court impliedly consent to jurisdiction. The implied consent is to the quantity of ownership was in the record. And the sole reason why the court awarded all the property, all the house to the wife was because the pleading requirement it deemed was insufficient. There's significant prejudice. That house was valued at over $1 million. So that's a significant issue.
You're
And I
into
also,
your rebuttal time and you can use it now or later, but not both.
let me just finish up this retirement account. And let me have 2 more minutes of my principal time. The court can reverse simply on the pleading requirement, but also there's cases out of the 2nd district and the 3rd district, the Ortiz case and the Riley case, which have held that pleading is not necessary in partition actions anymore, that the court has the jurisdiction under equitable distribution to order the sale of property and deal with it. So the court has not adopted that in this particular district, but we submit that the court should. One last point I'll make on this other issue was that the husband was assessed $132,000 in an account, which we submit again was an abuse of discretion. On the simple, but there was no finding under Roth and these cases that there was any intentional misconduct. The court's only finding in the final judgment was that he paid money out of this account to pay bills, and it was a violation of a standing order. And that simply, it was not correct. The standing order actually says that a party can pay expenses out of the account, and that's not a violation of the standing order. There was no other findings of intentional misconduct. So, and the court, and there's cases out there that says dissipation does not, depletion of the account does not equal dissipation. And I cite that Schmidt case, which is out of the 1st district in 2023, which is reported at Westlaw 6527563, October 13th. So he was assessed $132,000 on that, and he spent it, and the date of trial balance was $173,000, a significant difference. I will defer to the brief with respect to the arguments on the motorcycle, on the tax liability, which they've conceded as error by not including it, the rental deposit, and the motorcycles, as I addressed to the court a few minutes ago. The court committed error by misclassifying those assets, and I submit that there's basis for a reversal. Counsel tries to argue the tipsy coachman document to bootstrap his argument. He says in the brief that there's a technical error by classifying the motorcycles. There was no technical error, there was an error. But I'll defer to the court with respect to any of the other issues with regard to the misclassification of the assets. In closing, I would make one point.
You have a minute left, and that's including your rebuttal time.
This is a classic example, Your Honors, of what happens when a court automatically signs off on a judgment that's submitted by one of the lawyers. It's full of errors. And I submit it should be reversed on equitable distribution and alimony grounds. Thank you very much.
Thank you. Counsel, when you're ready. I think you're on mute.
Thank you, Your Honors. Michael Shemkus, appearing on behalf of the appellee Tracy Knott, the former wife in this case. Your Honors, I'm going to respond to some of counsel's points a little bit out of order to try and deal with the easiest ones first. Number one of the last arguments raised just now was that there was no finding in the final judgment of intentional misconduct in order to support the dissipation of account number 3497. I'd like to direct the court's attention to page 7 of the judgment, wherein the trial court expressly finds, quote, "This court finds husband's depletion of Bank of America X 3497 to constitute clear, intentional misconduct, given the facts and circumstances of this case." So, to clarify, there is clearly a finding of intentional misconduct, which is a required finding to support a conclusion of dissipation, contrary to representations made.
Mr. Shimkus, can I ask what evidence in the record is there to support that finding of misconduct, other than the fact that the money was spent?
Absolutely, Your Honor. So here we have, so this goes to the competency and substantiality of the evidence to support the finding. Here we have former husband, Mr. Knott, taking the stand and testifying under oath that, at least on direct, when he was on direct by opposing counsel, he was questioned. What did you need $132,000 of cash for within 8 months? And he was asked this question repeatedly during trial for each withdrawal that he took that aggregated to the $132,000. And for each response, when opposing counsel was asking him, the answer was, "I can't say, I can't recall, I don't remember." It wouldn't be until later when his own attorney comes on and asks him, "Isn't it true that you use these monies for living expenses?" And the only response given by former husband was the word yes. We also have evidence in the record, the bank statements from this particular bank account, dating back for several years prior to the filing date in this case, where the single largest one-time withdrawal of cash from the account by Mr. Knott amounted to $2,000. However, once former wife filed her petition for divorce in December of 2019, within a month or two, Mr. Knott goes to that account, and for the first time in this account's stated history, insofar as the record is concerned, he withdraws $100,000 in cash. So it doesn't take a lot of deductive reasoning for the trial court to be able to say, well, what was Mr. Knott's use of these funds prior to divorce proceedings? Oh, the most he ever withdrew was $2,000. And what did he do once the divorce proceedings commenced? He withdrew $100,000 within a month and another $32,000 within the ensuing 7 months. And when questioned by Ms. Knott's attorney as to why he needed that cash so desperately, he couldn't say. And then in rehab, from his own lawyer, he was simply asked to say yes as to the fact that as to the assertion that he used it for living expenses. I would submit to this court that that is all the evidence that the trial court needs to make a credibility determination and to make a determination that the expenditure of those funds did not constitute proper conduct. And the inverse of that, of course, is that this was intentional misconduct. I hope that answers the question, Your Honor. With respect to the point that alimony in this case was somehow decided without regard to Mr. Knott's net income, that representation is completely belied by the final judgment. We have 3 pages of findings reducing gross income to net income found at pages 31 through 34. The trial judge uses the former husband's own financial affidavit to inform that analysis as the trial court works step by step to consider living expenses, taxes, etc., until it distills a number down to net income. So I'm not sure what the argument is in regards to that. With respect to the motorcycles, as we stated in our answer brief, we concede right away that appellant is correct in pointing out that there is a bright line rule in the state of Florida governing when an asset can be deemed marital versus non-marital based on the filing date. And we concede factually that the two motorcycles were purchased and acquired by former husband after the filing date. Ergo, they are properly characterized as non-marital. That is not controversial. However, that need not end the analysis. We do cite to the Tipsy-Coachman doctrine, and for good reason. The Tipsy-Coachman doctrine stands for the proposition that the court reached the right result, albeit for the wrong reasons. So long as there is any basis in the record to support the result, the Tipsy-Coachman doctrine can find footing. Here, the alternative theory could well be unequal distribution, which is available under section 61.075. And for unequal distribution, the court need only include some factual findings in the judgment relating to the subsection 1 factors. One of those factors is subfactor J, quote, any other factor necessary to do equity and justice between the parties. Within the four corners of the final judgment, the trial court found that former husband used roughly $32,000 of admittedly marital money in order to purchase two motorcycles for himself after the filing date. The trial court awarded the motorcycles to former husband at their value in the equitable distribution scheme, implicitly giving former wife credit for 50% of their value. If the court had not given former wife 50% of their value, we would not have a distribution of marital assets serving equity and justice, which is what one of the factors of unequal distribution provides for. And think about it this way. Suppose that what former husband has actually done here is of the $32,000 of admittedly marital money, $16,000 of that, 50% of that, is presumptively former wife's money. He then takes both her share and his share, deprives the account of that money, and then buys new assets after the filing date to his own individual benefit, depriving the marital estate of that money. So here,
if I may, then from what I recall, tell me if I have this right, with respect to the motorcycles, is the record evidence that at least one of them was purchased in part through some cash that the husband had, and then some kind of accounts receivable, if I may, or that was related back to the business?
Your Honor, I don't recall that being the proof at trial, but your memory may be stronger than mine in that regard. So
if there's a valuation, say the $132,000 that we're discussing, right? Say that's on the data, that's at the data filing, right? And so the court counts for this money on data filing, and then counts for an asset presumably, or at least arguably, purchased with this cash after the data filing, and say that's $32,000 worth. Didn't the court kind of count $132,000 and then another $32,000, whereas the cash arguably has been then taken from the cash account and then now moved towards the motorcycles?
If they were the same dollars, yes, Your Honor, but I'm not sure the evidence is clear that they were the same dollars. We know that those dollars came through that account. And so there is an argument there that those dollars were at the very least commingled and converted into marital dollars. Whether they represent the identical dollars that were included in the dissipated $132,000, I'm not sure the record is clear on that.
Thank you.
You're welcome, Your Honor. We also have, in a completely separate from the Tipsy-Coachman doctrine, is the harmless error doctrine. And I cited to two decisions, Vaughn and Maddox, in the appellate brief, in the appellee's brief, that provides for the propriety of that treatment in this instance. I'd like to move on to bigger fish to fry, if I may, Your Honors. With respect to the partition issue, personally, I find this issue to be very intriguing, particularly in light of the decisions that have been issued from the 2nd District and the 3rd District with Riley and Ortiz. If we read, first of all, I disagree that the pleading standards for partition were met in this case. At best, what we have is we've got a shotgun pleading by former husband listing all of the potential forms of ownership that he and his then wife may have had in the property at the time that he filed his counterpetition. I would submit to the court that this kind of shotgun pleading does not adequately serve the purposes of pleading standards. I would liken it to something like if a requirement were to identify the first initial of one's last name, if that were a statutory requirement in a pleading. I'd submit to this court that if that person files their petition and says the first initial of my last name is either A, B, C, D, E, F, all the way through Z, I would submit to this court that is not what the pleading requirements require. They require more. They require something that's informative to not only the opposing party, but also to the court. That wasn't done here, plainly. It was every
Counsel,
form.
if we were to conclude that the partition claim was pleaded sufficiently, would it matter? In other words, would the trial court not still be free to apply the equitable distribution principles instead of partition principles, or maybe incorporate them both? Help me understand how the trial court could resolve a partition claim on one hand and the guidance from the equitable distribution statute on the other in deciding, how to dispose of the house.
Absolutely, Your Honor. So I guess in the first instance, as a threshold matter, I would respond with the trial court actually gave two reasons for its distribution of the property to the former wife, not just one, as the appellant takes in this case. The trial court not only found that partition was improperly pled, ruling it out as a possible remedy, but it also independently found in the same final judgment that the only party seeking distribution of the property was the former wife. And it cites to several factors for the court to consider in rendering an equitable distribution of marital assets. And two of those pertain to the desirability of retaining an asset, given the stated purposes of one or both of the parties. And here the former wife was the only one to testify that she wanted it. She wanted to remain in it. Former husband could care less. He just wanted the liquid value. So I would initially respond to Your Honor's question by stating that we can ignore the partition issue entirely and find that the trial court is abundantly justified in exercising its discretion to award the home to the one who asked for it within its equitable distribution authority. Point, period, proven. Now, more to Your Honor's point, I believe, is what is the significance? What if you find that the partition action was properly pled? It's a bit of an uncomfortable concession for me to make, but I need to make it candidly. I think that there's plenty of case law stating that partition, when properly pled and properly proven, is a matter of right. And so if it were actually properly pled and properly proven, which it wasn't, then I believe the trial court's hands would have been somewhat tied. The only exception to that rule, Your Honor, that I'm aware of in case law is under circumstances where the court awards that same property to a party objecting to partition because they seek to use it as an exclusive use and occupancy for the benefit of the children. That's where I've seen the exclusion apply. So I hope that answers Your Honor's question. Now, to the extent that we are citing to cases like Ortiz, cases like Riley, for the proposition that these decisions are even binding in their own districts. For one, it goes without saying the 6th DCA is not bound by the decisions of the 2nd or the 3rd. But for two, I would submit to the court that the 2nd and the 3rd aren't even bound by those decisions regardless. This notion that partition is no longer required to be pled to compel the forced judicial sale of real estate. I make the argument that the holdings, that the excerpts in those decisions upon which appellant relies is pure dicta. In both instances, the decisions turned on completely separate issues and were remanded for tasks unrelated to pleading. And also, I would argue to the court that even if that were the decision, the binding decision of the second and the third, I'd argue it's bad law. It's bad law because it offends notions of statutory construction. We have an entire chapter devoted to how judges should go about forcing the sale of real estate. It's called the partition statute. It's chapter 64. That is far more specific and tailored to the judicially forced sale of real estate than is this line, this tiny excerpt from section 61075 that talks about the court's jurisdiction to distribute property between the parties. And then the last point I would make is even that sentence is flawed in its application. Between the parties is what the statutory language is, and it's the same language cited by Riley and Ortiz. Between who? The parties, not between the parties and a third-party buyer. That offends notions of plain and ordinary meaning of language. So for all of those reasons, the trial court's award of the home to the former wife was abundantly justified and equitable. Moreover, if the court hadn't done it and done what former husband wants, he would have received half of the equity, roughly $383,000, and then he would turn around and owe her an equalizer of $383,000. Where's he going to get that to pay her? It's going to be the money he just received. He just turn it over and give it to her. So I don't even know what the logic is behind seeking the compelled sale and the distribution of half the proceeds, because it completely upsets the equitable distribution and then requires former husband to turn around and pay it back to former wife. Now, with respect to the valuation of the company, this double dipping argument, I'd like to start with an analogy first. The analogy is, imagine a W-2 wage earner earns their money throughout the year, but rather than spending it, they put that money into a savings account. And then at the end of the year, or at the start of the new year, they begin to spend it to cover their expenses. But if the wife filed for divorce in that instance, while there was still a balance in the savings account, no one would be arguing that that savings account is not a marital asset to be equitably distributed. And then once the asset was equitably distributed at its face value, that's what we do with most bank accounts, then the next analysis turns on what is the husband's earning ability for purposes of alimony. It's a completely sequential and separate analysis. And there we would look at his W-2 salary, and we would say this is how much he makes throughout a year, and this is his gross income, and we would begin to reduce it by net until we get to a number for alimony. But no one would be arguing that because the dollars in the savings account were earned from husband's work, that they are somehow exempt from equitable distribution. Or conversely, that because we've accounted for the fruits of that labor in the equitable distribution step, that we should somehow discount the husband's calculation of gross income for the alimony step. That is not the way that equitable distribution and alimony decisions work, and that's not how the statutes design them to work. Here, we have the same concept. Former husband runs a business. He generates money in the bank throughout the year. The court valued that business in equitable distribution according to its net asset, which includes the money in the bank. It then rendered an equitable distribution of that business to former husband on the spreadsheet. And then the next process entirely was, what is former husband capable of earning in a year for alimony? And for that, the court simply looks back for the indicia of that earning. The indicia of that earning is what he amassed in his corporate bank account throughout the year. He then uses that number for the math of applying the alimony analysis, and then arrives at a figure of ability to pay. We are not dealing with the same dollars. We are dealing with past dollars accrued prior to the filing date that went into a business bank account, that for purposes of equitable distribution. And then when we talk about alimony, we talk about what is husband capable of earning in the future based on indicia, proof of what he's earned in the past, which is, by the way, how we always figure someone's inability to earn, is by looking at what they've earned in the past. That does not mean we're using the same dollars for ED and then using those same dollars for payment of alimony. Yes, we're using them to calculate ability to earn, but that's how we always do it. That's how the law does it. So Stenikin stands for the same proposition. The fact that it used a different valuation method is immaterial, because both its valuation method of capitalization of earnings versus the net asset valuation method used in this case, both capture figures leading up prior to the filing date in the case. This is not a double dipping case, either on the alimony front or the equitable distribution front. I'm out of time. Thank you, Your Honors.
Thank you, counsel. All right, 33 seconds. You may begin.
I simply would say that we stand on the brief on these issues, on all of these issues. Clearly, when counsel attempts, he spent a lot of time on this issue about these motorcycles. But it's clearly that the big issues in this case, that the court error, were the value of the business, the net income for alimony purposes, this $132,000 account, which my client got assessed against, and this partition issue, which is clearly pled properly. And secondly, that's the sole basis for the court to give it to the wife. The court said in the final judgment that since the husband didn't have a right to this partition, I have no other remedy than to give it all to the wife. And that's severely prejudicial. And that is the error that we submit under the abuse of discretion argument. And I would also ask the court to take a look at, it's not dicta in Ortiz. It's not dicta in Riley with respect to the lack of pleading requirement. This court can adopt those principles, or it can say that the pleading was proper with respect to the partition and reverse on that point and allow that particular remedy. As counsel said, it's a right that the husband had with respect to the right to have a partition. Thank you.
Thank you, counsel. We will be in recess.